All right, let's do this. Dun, dun, dun. Done. Right. Harassment and coercion. These are lovely words, aren't they? It's just it sounds a little bit nastier. It sounds a little bit meaner, but in practice, like a lot of the statutory rules that come in the Australian consumer law, the bar is actually lower to proving these things. And so there's a couple of things you need to know, and I'll bring the section up there. Section 50 is unusual in that it has no trade and commerce element to it. You do not need to be, or the person that is doing the particular harassment or coercion-y behaviour doesn't need to be in trade and commerce for you to bring an action against them. There it's got, a person must not use physical force or undue harassment or coercion in connection with, and it lists 4 of those things: the supply of goods or possible supply of goods or services, payment for goods or services, and things to do with land or interests in land, including the payments thereof. And so this section is just using normal principles of statutory interpretation is easier to go through and prove. Why? Because if we think about this use of physical force, that's pretty broad. The use of physical force, and it only has to be in connection with, using physical force in connection with one of those things, is of much wider application than this need to prove the unlawful or unconscionable threats in relation to common law duress. It's much broader, and it applies more broadly than the other components of the Australian consumer law, in particular Section 18, and in fact Sections 20 and 21, 22, which we'll do next week. This stuff can apply to private sales. So the example I had last week, I buy a boat from Leanne, and she threatens to bust my kneecaps up if I don't buy the boat. Even though that's a second-hand sale and land's not in trade and commerce, it's still physical force, right, undue harassment or coercion in connection with the supply of goods, possible supply of goods. Maybe I'll run away. Okay, so that's the section, and I think it's helpful to leave that in the back of your mind, this idea that it can apply for private stuff as well. So we've got to look at a couple of words here. Physical force is pretty straightforward. This undue harassment and coercion. Okay, undue harassment. There, and McCaskey. Now, these cases, by the way, I think all of them involve, I don't know if any of you guys have done any reading on this. What class of persons do almost all of these cases involve? It's debt collectors. They make up the bulk of the case law concerning what's now Section 50 of the Australian Consumer Law. Debt collectors are scallywags, and they are the types that will call people and, again, in the ordinary sense, harass them. So here we're thinking, well, what is the word harassment defined? And the court said no. It starts with the ordinary meaning of the word. Remember doing principles of stat interpretation with Van, I think? Did Van teach you guys? He used to be. Actually got taught it by Rachel as well. She taught me everything. It's amazing. And so doing stat interpretation, you start, when you're reading a statute, work out what the structure is. Then you start with any given word. What is its ordinary and natural meaning? And that could be modified by stuff later on, but that's not what you start with. Start with the ordinary natural meaning of a word, and you can confirm it in the dictionary. You don't go to the dictionary first, but you can confirm your own understanding of that word by checking with the dictionary. So don't rock up to court and say you're on a harassment is defined in page 72 of the Oxford Dictionary. No, it doesn't work. So here they've taken some general purpose words and synonyms, conduct that tends to intimidate, embarrass, ridicule, shame, or otherwise distress the person with whom the conduct is targeted. And legitimate harassment. So this is, and again, here we're thinking debt collectors. It's probably a useful mechanism to think of that as the sort of the main part where this stuff comes up. Can debt collectors call you up? Yeah, of course they can. You owe someone money. And in the case of this McCaskey and an ACM, that usually they're on-sold debts. They're debts where an entity like Telstra you owe money to, and so they sell that debt for a certain number of cents to the dollar to these debt collectors. And their whole business model is to try and squeeze that money out of you. That is what they do. That's how that works. And yes, they can call you up and say, if you don't pay this money, we are going to take you to court. And then they can call you back at some stage later and say, have you paid this money yet? No? Okay, better pay this money or we'll take you to court. And then they can call at some stage later and say, are you going to pay this money or are we going to have to take you to court? Yeah, well, that's a good question. It's a common law test. It's a common law set of rules. Probably. But the key thing to note is that conduct designed to embarrass or designed to try and serve the legitimate purpose of asking you to pay for that particular debt? You are allowed to be reminded about debts, but if the purpose of the conduct is designed to embarrass, rocking up in this lecture now, as a debt collector would be of much greater embarrassment to people in this room than turning up to the house, turning up to them on the street when there's no one around. It's really to do with the context. That's what Justice French's event was saying, is that, look, we're not actually saying debt collecting is not lawful. It is lawful. But how they go about doing it, and the methods that they use, and the amount of times they call, the times of day that they call, whether or not you're right, whether or not they turn up in person, whether or not they turn up to your place of work, all of these factors are taken into account by the court in order to determine whether or not this was a legitimate exercise in trying to seek repayment of a particular debt. It's also important to note that when a debt collector calls up and says, can you pay this debt? And like, oh, I don't get paid till next Thursday. Sure, yeah, I'll try and give you money on next Thursday. All right. And then you wait till next Thursday and you call back and the same pattern comes on like that. Now, as a debt collector, does that mean that you'd only be able to call them every Thursday? Again, the courts do and are a little sympathetic to debt collectors. They actually probably could call you a bit more regularly than that. Maybe not every day. Oh, you pay, yeah, sure, sorry, yeah. Good, yeah, going waiting outside. I mean, come on, we've all seen it. I don't know. There's that waiting outside the FPOS machine or the little money things. The bookies are standing there just waiting, and you're like looking at the time, waiting for your pay to come through, looking at your clock. Oh, actually, it's JCU payday right now. I think this afternoon our pay comes in. Not that I get paid. Just do this for fun. Okay. And so this thing here, is it designed to intimidate? Is it designed to demoralize, tire out, exhaust a debtor? I love that, to exhaust them, to tire them out, to just make them want to go and live somewhere else. That's where things go above and beyond. And look, you notice that there's no numbers there. There's no hard and fast rule. There's no number of times. And after this case, that's recent. This was actually just before the class last year. Some guidelines that got issued by the Commonwealth Government in regards to debt collectors, in terms of what they can and can't do and the times that they can and can't. It actually came at the request of a lot of the community groups Community legal groups, you get debt collectors all over the show. I applied last year for QCAT for my fence. You guys may remember at the start of last year, there was a rain event. Not the same as the rain event this year. Oh, bad this year. Last year there was a rain event and our fence got knocked down. We were like the only place in the city, a little mini tornado like that. And I think we applied for QCAT in May. May might have been a bit later, might have been June. May, June. And the hearing was in November. Maybe it was July. But it took about 4 or 5 months for it to come up. And I had another matter at the same time, which took about the same length of time. That was a consumer dispute. Largely for these things, you have to do mediation first. So they'll go through and book that. That takes a bit of time. Sometimes the registrar will just say, "No, no point doing mediation. Skip straight to the hearing." Although oddly, that didn't take any of the two. One of them went to mediation, one didn't, and it still took the same length of time for the hearing to come out. So about 5 months. Okay, so that's undue harassment. Now, you might recall though, the phrase, the way the section is phrased. Oh, no, I'm going to go back. You put on your stat interpretation hats here. All right, or if you've got the section in front of you, you can have a look at it. The way that this section is phrased, physical force or undue harassment or coercion. What's the problem here? Jordan? No, I don't know. No. Was there a problem where it says undue harassment or coercion? Is it undue harassment or coercion? It's two separate things. Or is it undue harassment or undue coercion? Which is it? Which of the two is those things? There's ambiguity in the statute. If there's ambiguity in the statute and there's two ways that could be preferred, what do? We look to the... No, yes, yes, we have a winner. Yes, the dominant paradigm and of statutory interpretation is, and it's important to know, you don't go to that first. You actually go through it when you're reading a statute. And if there are two, in the way, if you guys looked in the Acts Interpretation Act, section 14, capital A of the Commonwealth one, and 15, capital A, capital B, I might have quoted that wrong, in the Queensland one, they say, if there are two or more possible interpretations of a statute, the one to be preferred is the one which most aligns with the purpose of the legislation. People misquote or misread or don't understand the purpose of the approach. It's a real shame that we don't do legal research and writing again in your 4th year, but I'm working on that at some stage. Get back to you on that. It'd be awesome doing that in your final year. Doing some coding, doing some AI stuff, doing some legal method. So here what they do. Yeah? Well, you'd look, when you're going through and you're interpreting those things, you're trying to resolve ambiguity. And the idea is that in each given step, when you're going through and doing that, you're trying to resolve ambiguity, but explanatory notes don't form part of the act. You look at the statute, can I interpret this using the purpose approach either which way? If there is still residual ambiguity, and we can't determine the purpose from the act itself, and the purpose of the act and the little heading there, then we can look, the court may look at extrinsic materials in that next phase. But it's really about going through. If it's fine with this bit, they don't go to this bit. That's it. Although, of course, if ever there's ambiguity and there's two parties in our adversarial system, both sides are going to argue. Yes, there's ambiguity. No, there's not. Okay, so just make note here. Went back and looked at this, and it turns out that no, here it actually just means the coercion is a stronger word anyway. It's not undue coercion. It's just coercion. So that's why this slide just has coercion, whereas the previous slide has undue harassment. Okay, and it's to do with changing somebody's choice. It's not about completely overbearing their will, forcing them to do something. It's stopping or restricting them in some way. bending them to your will, not strictly speaking replacing your entire, replacing your will with their will with yours. But like those debt collector cases, McCaskey and others said that calling somebody up and saying, pay this or we'll sue you, is actually not coercion. That is an ordinary part of business and a mechanical aspect of law. The thing is about debt collectors, I hate to break it to people, and I spend a lot of time doing community legal, that debt collectors are right. These people didn't pay their debts, and the debt collectors are just trying to collect what these people, the money these guys have already spent. However, they don't care how you spent the money. That's not their business. Certainly not their business model. But in terms of where the law sits, strictly speaking, debt collectors are actually in the right. They're the ones with the legitimate claim of right to seek some form of compensation. That's the tricky bit there. And so courts, while not wanting to let debt collectors run rampant everywhere, they're still very sympathetic. That's what these guys do. It's an important part of our economy. And if we didn't have debt collectors, people would be breaching particularly small contracts here, there, and everywhere. Okay, but going above and beyond, telling somebody of their legal obligations, essentially threatening them, intimidating. If you don't do this, you're going to be in court, we're going to have you in court, you're going to be in there for 18 months, it's going to make your mum cry. Things. So many of my life decisions have made my mum cry. And when we're looking at that, though, leave that in the back of your mind. Look, it's conduct that goes above and beyond. Conduct goes above and beyond what a normal, asking somebody for money in normal business arrangements. Doing it 7 times a day, but particularly doing it in situations where pay us the money. And then coming back, particularly in situations when people say, oh yeah, I'll pay the money. And then coming back a day later, where's our money? Oh yeah, I'll pay the money. This can go on for a long time. But it's important to note the time between these things. And certainly I used to have this very, very frustrating style of conversation with my ex-partner who would ask me to do something, or remind me of something, or tell me that something needed to be done. And that was fine. Just, well, yeah, I'll do that. And, for example, I'll take the cat to the vet. Okay. Then remind you of something before the end of that day. Like it'll be a Sunday afternoon. And then remind you later on that day, take the cat to the vet. I'm like, yeah, yes, I'll do that. But since last time you asked me, I've had no opportunity to do that. Or we would be in Toowoomba. You need to do this. It's like, yeah, you've already asked me that, and there's no opportunity to do it. So that conduct, look, perhaps I'm just moaning and whinging about this particular factor, but it's that style of conduct that's what the courts are really talking about. If you are going and asking people for money, and then not giving them a reasonable time for them to actually go off and do the thing you're asking them for, you're going to have a pretty hard time proving back to the courts that this wasn't going to be some sort of harassment type behaviour, harassment or coercive behaviour. That's where that sits. Okay, there we go. So if it goes above and beyond, and this is such Robert French writing. You guys, it's one of those nice things. You guys are first year now, and so you would have read cases, and you would have started to get a bit of a handle on where things like Lord Denning likes to use all sorts of flowery phrases and famous prose. But you'll notice in terms of the High Court judges, how they write, and Robert French would just use so many words. And you just read it, these just dense judgments, and he didn't need to use that many words. He could have done it more succinctly. I don't know. Anyway, that's my personal thing, and this has gone out to YouTube, so judge if you ever see this. I'm not being critical. But just note, you'll also note some other judges in the High Court will use much more succinct. Sometimes they also use vague language too. Going back and reading Justice Murphy's judgments, which you guys, I think you do for LA1101 as well. You read those, or some of them which are a lot more upbeat, Justice Mason's and so on. Okay, anyway, that is not quite the end of this section, because I'm going to talk about remedies. This next slide looks very, very similar to previous ones that we looked at in terms of the Australian consumer law. These are the standard ACL remedies. Pretty common thing is an injunction. This particular area is one where injunctions are far more likely to be granted. Why? Because if the debt collector is doing this, getting an order that says, debt collector, don't do that thing, otherwise you'll be in contempt of court and we'll lock you up. Usually they listen to things like that. And the ancillary orders that are in section 243, they can come up as well. That idea that you've got a variety of mechanisms. The whole reason these things exist, by the way, is to try and really stop this conduct from happening. But the reason why I'm bringing this up as a separate area is that harassment and coercion is something where these special, what they call the non-punitive orders in the ACL can actually come up. So debt collectors that do naughty things, particularly large institutional debt collectors that have policies that are naughty and they've gone and done wide-scale harassment and coercion, can be forced to do a variety of things, not strictly speaking, to compensate the particular person who's being harassed or coerced. So one of them, for example, an adverse publicity order. That's basically putting out an ad in the newspaper saying, oh yeah, we did bad, sorry about that. Actually going and apologising for the certain types of conduct and stating how they're going to go about changing such things. I love this one here in 246. Establish compliance or education and training programs. Again, institutional players. This remedy doesn't often come up, but it can. But it's much more likely in things like Section 50 breaches, because it's really going back to the same parties, debt collecting agencies, and saying you need to change this. We as the courts are actually almost we've been given scope by Parliament to tell you that you're being naughty and tell you need to do this, this, and this, and we're going to do that right now. So that gives them scope to do that. Again, those here, including myself, who are much more of a fan of Parliament being the one who makes laws, not unelected judges, may notice that this actually gives judges a lot of scope to make policy. They're actually going, particularly to tell institutional players in certain sectors, to go off and do things. And it's, coercion, harassment and coercion, or undue harassment and coercion, are the statutory mechanisms. It has a much lower bar, and you can receive remedies under the Australian consumer law. Duress is a common law action. It has a higher bar. It must fall under one of those areas where you threats to the person, threats to goods, or threats to economic interests, and you get common law remedies, which can either be the right to rescind or undo the contract, which is subject to those bars to rescission, as well as being able to run at the same time an action in tort, the tort of intimidation. And because Section 50 doesn't have the trade and commerce requirement, almost always you want to be running under Section 50. But in some situations where, for example, the harassment and coercion, I'm trying to think of a situation where you wouldn't be able to use the statute. If it's supply of insurance policies, I'm trying to think. I don't think that falls under Section 50. I'm actually quite curious to have a look now. Let's have a little look. In fact, that's probably a good task. I should have said it as a trick question. In situations where duress might apply, where we couldn't use the Australian consumer law, because I think I gave you guys the example for me personally where I had to use common law misrepresentation. I couldn't use the Australian consumer law, Section 18, because I was trying to sue the Queensland Justices Association, which makes me sound terrible as a human being. Here, it still has to be in connection with one of these things. Supply of goods and services, payment for goods and services, sale and grant of land, payment for interest in land. So if the particular contract is not for one of those things, so an example might be a contract to release existing contractual rights. Strictly speaking, it's not one of those. Therefore, it wouldn't count. A money lending arrangement wouldn't count under those things, which is interesting actually, because that just notice that money lending that's connected to goods and services. So if you have a hire purchase arrangement, that would fall under this. Whereas if you just lend somebody $10,000, that's not a good or service. So that wouldn't fall under there. So there we go. I'm learning new things every day. What are some other examples? I think contracts for insurance wouldn't fall under this either. And banks. Your banks and your insurance companies in this country have a lot of power. A lot of power. They get to opt out of a lot of things. So I'm going to end this recording, and we're going to start the next one, which is undue influence. We're going to kick that one off for the rest of this this lecture, and I'll close this. It's going to take about 5 minutes. That's all. So just bear with me. It'll be about 5 minutes, and then we'll kick off again for the rest of the afternoon. Thanks.